Good day, everyone. My name is Scott Reich, and this is Crime Talk. Yes, this is the weekly recap of all the top stories throughout the week, conveniently located in one location. We hope you enjoy the show. Thanks for watching, and we'll see you next time on Crime Talk. Is the accused Delphi murder suspect going to get some help? Well, looks like it. Remember, Richard Allen is the suspect and is accused of killing Libby German and Abby Williams in Delphi, Indiana, back on February of 2017. And he is set to stand trial next October. Now, Allen's original defense attorneys withdrew from the case just before a hearing last month in Fort Wayne, Indiana. One of the attorneys then filed a motion requesting that the Judge Fran Gull, be removed, saying that she pressured him into withdraw and that the move was not voluntarily done. Now, Judge Gull claimed that the disqualification was necessary due to gross negligence related to a leak of evidence. Well, on October 27th, the court appointed Fort Wayne attorneys Robin Screaman and William Labrado to represent Mr. Allen. Now, in court filings filed on Allen's behalf, he requested that his original attorneys be added back to his defense team. Now, the Indiana Public Defender's Council said on Friday to the Indiana Supreme Court that they should step in and reinstate Allen's original attorneys. The Public Defender's Council filed a brief with the court arguing that the removal of the attorneys wasn't handled properly and has the potential to undermine the case. Now, here's a good summary of their argument from their brief. As a final point, although this brief focuses on statutes and procedures designed to protect the independence of defense counsel, we should not lose sight of the person most affected. Public defenders do extraordinary, life-changing work every day in courtrooms around the state. Mr. Allen was pleased with the work his initially appointed public defenders, Mr. Allen, and the public that funded his defense should be entitled to more than vague and broad concerns about gross negligence, and that a judge cannot and will not allow these attorneys to represent you. I can't do it, sir. I just can't. Such statements do not engender confidence in the criminal justice system for criminal defendants, many of whom believe that the appointed counsel is not a real lawyer, but a public pretender or a lawyer who works for the state. When followed, the statutes and decision law outlined above provides some means to dispel these misconceptions. When not followed, the trust and rapport developed during the full year of intensive representation is lost, and Mr. Allen is left to wait 9 additional months incarcerated in the Department of Corrections under conditions that he and his counsel of choice have stated undermine his ability to prepare his defense. Now, this is significant, okay? Obviously, we have not seen the transcript of what took place between Judge Gull and Mr. Allen's attorneys. But for an attorney to be told that you're getting off this case now, or I will tell the public what you did, okay, the defense attorney should have said, bring it on, Judge. But I understand, small community, the judge is telling you you're off the case, you're kind of ambushed about it, you don't know what to do. I get it. The attorneys have since gone back with the blessing of Mr. Allen saying, put me back on the case. Now, here's what I don't like the way Judge did it. If she thought that there was something so egregious that these attorneys did, then there's a procedure for that. It's called a grievance. But Mr. Allen, although he's not entitled to counsel of his choice when he's represented by the public defender's office, like he can't say, I picked this one and this one, normally, but in this particular case, it seems as though the judge was the one that created the conflict, if there is even a conflict of interest in this particular case. And yes, it does undermine the judicial system when basically what it appears to be is that, hey, this guy, Richard Allen, accused of killing 2 young girls in a highly publicized case, had the audacity to have his attorneys put on a zealous defense. It looks as though the court's saying, we can't have that. How dare you question the police in any way whatsoever? Well, there is a place to test that. It's called court. Legal and competent evidence, the cross-examination that takes place, the greatest truth-seeking tool ever created. So it looks a little fishy when the judge just says, we're going to get rid of this particular case. I don't like it, and I think the attorney should be put back on the case unless and until I see something differently in that particular transcript. If it's so bad, they should be grieved. They should have their law license removed, not just terminated from the case because they're being zealous advocates. Looks bad, Judge Gull. I think the Indiana Supreme Court is going to change the judge's mind. All right. First on the docket, the prosecutors moved to make all those miscellaneous perfunctory changes to the indictment in the case of Chad Daybell. Now, as you may recall, in the Lori Vallow case, there were some amendments that the prosecutor sought to make right before their last witness in their case in chief. The judge was not happy with the prosecutors. The defense objected to the amendment of the charging document, an indictment, up until the last moment. The defense had prepared to make their arguments under the particular subsection that was in the indictment. I mean, could you imagine being allowed to rely upon the indictment, the charging document that they went to all the trouble with, and then being allowed to just change it, the simple request? And I don't know, this is apparently a rule in Idaho that you can amend an indictment. Unbelievable. Normally, when you make any amendments to an indictment, you have to go back and supersede. Supersede means to replace that was before it. Hence, when you have an indictment case, they have a indictment, then you have a superseding indictment, and if they make more changes or add defendants or change the paragraph under the statute that they're being charged under, the defendants would be, you have a second superseding indictment and third superseding indictment, and so on and so on and so on, because that's the way it was meant to be. Only in Idaho, okay? Only in Idaho were they allowed to do it in the Lori Vallow case. I think it's an issue on appeal. I mean, we're not in county court anymore where you get to amend the charging document right before you start trial. We're talking big boy court. We're talking a homicide case, and the prosecutors messed it up. And yes, we can go back and find the video where I said if the prosecutors want to do this correctly, in the Chad Daybell case, they may want to go get another indictment and supersede and make the appropriate changes under the grand jury system. But the prosecutors said, hey, we're just going to file a motion to amend the indictment, and they want to modify the language in counts 1, 3, and 5 from the defendants, Chad Guy Daybell, Lori Noreen Vallow, and Alex Cox, to the defendants, Chad Guy Daybell, Lori Vallow, and or Alex Cox. Remember, they had all the different people. There are multiple people in a conspiracy, at least 5. They want to modify the language in Overt Act 10 under count 5 from months to months. You think, oh, that's just a perfunctory change. What's the big deal? Well, because it is an indictment. And the prosecutor's basically saying, hey, we're actually making this more difficult for us. But that's not the point. They're saying the subsection that we want as it relates to the theft statute includes the wrongful taking and obtaining and withholding another property with the intent prescribed within the particular statute. Now, they're saying that actually makes it adding an extra element to the offense. But that is not the point, okay? Now, I'm sure Judge Boyce is going to allow the amendment and say, well, at least we did it earlier before the last witness in the case in chief. But like I said, I've never seen an indictment amended on the fly. It is unbelievable to me. But the more we see about Idaho, things just are a little different, at least anywhere I've practiced and the federal courts that I've practiced around, for the last 28 years. But that is the change that is being made. Now, another motion that was filed, rather weird. It's a motion confirming there is no court order restricting contact between the defendant, Chad Daybell, and his co-defendant. So let me just read this motion. You would think the prosecutors would know what the heck was going on. It says on January 19th, 2023, a motion was heard in Lori Vallow's case, Fremont County case number 22-21-1624, requesting the defendants be allowed to meet with their respective counsel present for a strategy session. At the time of the motion was heard, the cases were still joined for trial, so all parties were heard on the motion. The court denied the motion, finding that the Idaho Rules of Evidence 507 would only be applicable for mediation, which was not occurring, concerns about the potential for the defense attorneys to become witnesses, and security of the parties. The court did not specifically enter any order restricting and or prohibiting communication between the defendants at that time. The state is unaware of any additional orders put in place by the court addressing the defendant's contact with each other or restrictions regarding that contact. Since the entry of the order on the co-defendant's motion for a joint strategy session, defendant Valo Daybell has been found guilty of all charges and was subsequently sentenced to life in prison on July 31st of 2023. At the time of the sentencing, the court transferred custody of defendant Valo to the Idaho Department of Corrections and, in doing so, relinquished jurisdiction over her and her case, with the exception of some of the limited purposes such as a hearing under Rule 35. That'd be ineffective assistance of counsel. The state is seeking an order finding and or clarifying that there are currently no restrictions in place by this court in the form of a no contact order or otherwise prohibiting contact between the defendant and the defendant Valo Daybell. If such an order was in existence, the state would seek clarification as to whether it would still be applicable for the defendant Valo, since the court has relinquished jurisdiction over her case and most purposes, including the ability to restrict her contact with others. Normally, in any case, there is a protection order that goes in place. It says you basically can't harass, intimidate, retaliate against any witnesses in the case, usually don't have contact with any co-defendants in the case, etc. A couple things happen usually on sentencing. Usually if there's a protection order, say, for example, I am convicted or the defendant is convicted of beating your wife, and there's a protection order that says don't beat your wife. Don't harass, molest, intimidate, retaliate against. That restraining order stays in place during the pendency of the sentence and even after parole in most jurisdictions that I've ever seen it. Here there was a protection order, or wasn't a protection order, but they said don't talk with the co-defendants. But why is the prosecution seeking clarification that the defendant, Chad Daybell and Lori Valo, can speak? Usually it's the defense that wants to clarify that to make sure nobody gets in trouble. So I think that's rather interesting. And second of all, why is the prosecution not aware of what was going on? And third, Chad Daybell, I'm not your attorney, but listen to your attorney's advice. My advice is, I'm sure your attorney is saying, do not talk with Lori Valo, your wife, because anything you say can and will be used against you. The privilege isn't going to protect you in any way. And so therefore, don't talk. It's almost like the prosecution is baiting Lori Valo and Chad Daybell to talk to see if they can say something incriminating to one another. Very, very interesting and very bizarre, to say the least. So, hey, we'll bring it to you as soon as it comes in. We get it right off directly from the court, which I think is interesting because we brought this to you. We brought you a story about some of the filings in that case last week in our live show that we did on a Wednesday night. Tonight it's actually Tuesday at 6 p.m. Mountain Time. And people were doing stories about it for the next 3 days. We brought it to you that night. So just saying, stick around to Crime Talk when you need the breaking news. Next on the docket, Linda Stanley. Where do I know that name from? That's right. She was the prosecutor in the Barry Morphew case. Well, that's right. The district attorney is being compared to the criminals she prosecutes. So Linda Stanley is already under investigation by the Colorado Supreme Court, their attorney regulation division, as one of the sheriffs in her own district has now urged her to resign. The sheriff said in an interview, one of the things that fascinates me about this line of work is that I've always tried to figure out, why do people do things that they do? That's according to the Fremont County Sheriff Alan Cooper. He said, I see a lot of Miss Stanley in people I've arrested and put behind bars. It's the same thought process it's everybody's fault but mine, according to the sheriff. Stanley, who is the district attorney for the 11th Judicial District, is under investigation by the Supreme Court for withholding information from the defense attorneys in the Barry Morphew case, and also launching a secret investigation into the judge that ruled against her office in several cases. Now, the sheriff said, I've worked with 6 or 7 district attorneys in my career. Some have been good, some have been average, and one has been really bad, the sheriff said. When asked, do you trust Linda Stanley to do large investigations, the sheriff said, no. You don't trust her, the reporter asked. He says, no, again. The sheriff is a Republican, just like Miss Stanley is, but he wants to see her out of office, even if it means the Democrat governor, Jared Polis, would remove her, and he would ultimately replace Linda Stanley with a Democrat. Now, the sheriff said, hey, listen, everybody makes mistakes. But in my mind, there are two types of mistakes. There's a mistake in judgment, which you can generally learn from. I like to turn those into life lessons. But then there's a mistake in character. A mistake in character is part of who you are, and that, the sheriff said, he can't fix. That's what he told the Republican Central Committee, that I can't fix Linda Stanley, which is why she needs to go. Now, the former Judge Ramsey Lama, who accused Stanley of launching a secret investigation into his family for retribution purposes for rulings he made in the case of Barry Morphew. Now, Stanley could end up potentially losing her law license in the Supreme Court investigation. Now, there are other things that could happen. You could lose your law license, be disbarred. You could be suspended. You could receive a public or a private censure, which is basically a reprimand of don't do it again. Somehow I think this is going to be a little more severe. I think this is going to involve a suspension, but I'm not attorney regulation. We'll see how it goes. But I think it's a lesson to all DAs out there. Turn over the discovery. Don't play games.
Alec Murdaugh, he had a big day in court today. What happened, you may ask? Well, let me tell you. The trial, as it relates to the financial crimes, one of the some 17 cases that was going to commence in just a couple of weeks as it relates to the Alec Murdaugh case, he wound up pleading guilty to all of those cases, and he resolved it. And by my count, there were 17 cases where he is going to plead guilty, a sundry of charges, a breach of the trust over $100,000, money laundering, multiple breaches of trust, computer crimes, as well as conspiracy. And the ultimate sentence of all of those cases, a combined 27-year sentence that he is going to have to serve, he being Alec Murdaugh. Now, what is the significance of this? Well, first, he knew he was going to be convicted if he went to trial, because during the murder case where Alec Murdaugh got up and testified to, he admitted to all of these crimes. So yes, it was kind of perfunctory to go through the trial. And Alec Murdaugh did state that he was glad for the opportunity to be able to plead guilty because he hadn't been given that opportunity before.
No, sir. Other than I'm glad to finally be given the opportunity to plead guilty. I am happy to be pleading guilty to these charges for a number of reasons.
Clearly, the state probably figured we got to deal with this murder case and all those issues come with that. Let's wrap this case up. And so they've agreed to the 27 years. Now, the sentencing is going to be on November 28th at 10 a.m. That's Eastern time. And basically, the judge has already said that he is going to accept the 27-year deal. But since this all was completed in somewhat short notice, if you watched the hearing live, you knew there were several hours where nothing was taking place. Well, apparently this deal had been in the works, but they got to do the paperwork. They had to have Alec Murdaugh review it, sign it, basically go back and sell it to the judge as well to go through the guilty plea colloquy where the prosecutor outlined the factual basis for all the crimes. Alec Murdaugh admitted to the factual basis to all those crimes. And like I said, he's going to get 27 years. Now, one of the things that Alec Murdaugh had to do to go forward today was, first, he had to withdraw his motion to ask that the judge recuse himself. As you may recall, the Judge Newman in this particular case, has already recused himself from hearing any post-conviction issues related to the homicide trial that took place earlier this year. And he has to do that. He's a witness to the case. He would have observed the clerk who's alleged to have engaged in alleged misconduct during that time period. He is a potential witness. And I don't even think it has to do with his extrajudicial statements that he made after the case, knowing full well that he was going to be presiding in front of Alec Murdaugh on this particular case. So that one's done. And so he had to withdraw his motion. Alec Murdaugh had to withdraw that motion so that the judge could accept his guilty plea. Makes sense. Perfunctory. Doesn't matter. 27 years. He's going to go. And here's the other stipulation. He's going to do 85% of that sentence. So do the math. 85%. 27 years. He's going to be in there probably for the rest of his life and not get out. And although it wasn't clear, you have to assume that this will be consecutive to his homicide conviction, where he's already serving multiple life sentences. The reality of it is Alec Murdaugh is going to die in prison. What else took place? Alec Murdaugh, to plead guilty to this, had to agree to restitution to be determined. Not a big deal. It's not like he's ever going to pay it back. And any monies that have been recovered through the firm or insurance have more than likely already been paid. Additionally, he had to waive his right to appeal anything that took place in these 17 cases as it relates to the plea, and he had to waive any post-conviction remedies that he may have to address ineffective assistance of counsel issues down the year. So that's done. What that means is these cases are all done. So, big day for Alec Murdaugh. And ultimately, we're going to be moving on from his case after the 28th as it relates to the financial crimes. Now, we still have to have the hearing as it relates to the alleged misconduct by the clerk in the homicide case. And hey, as the news happens, we will bring it to you.